Yeah, well, good morning, Michael. Thanks for joining us so much. We appreciate it. But one of our questions that we have today is, can you sue a doctor for misdiagnosis?
Yeah, I mean, this is kind of one of the most common things that we get in terms of the medical malpractice or the healthcare litigation questions. People say, well, I went to the emergency room and I had a broken bone and they didn't tell me I had a broken bone, and can I sue the doctor based upon that alone? Well, in medical situations, what we look at is, did the healthcare provider, nurse, hospital, doctor, do something that no reasonable healthcare provider would do under the same circumstances? In order to prevail in a claim for medical negligence, you have to have an expert say that somebody did something that was unreasonable and that they wouldn't do. So in a misdiagnosis situation, sometimes you're able to get proof that the diagnosis wasn't right, that it wasn't perfect. But that doesn't necessarily mean that you automatically have a claim. What you have to prove is that the healthcare providers didn't do what reasonable people would do to determine whether you were injured. The other thing that a lot of you have to prove in this situation is that as a result of what they did wrong, it caused an injury or it caused a harm. In diagnosis situations, especially like with trauma, somebody's in a car wreck, they go to the hospital, they don't diagnose them with a broken bone, but then they may go to another doctor the following day or within days and get treated. In that situation, you may have a hospital that should have diagnosed something or could have diagnosed something, but then you look at what injury did it cause, and that can be a problem in those situations.
I could see how that could pose a problem, but is there a particular timeline on this? So say if you realize this 5 years down the road, do you still have a good claim?
Yeah, I mean, misdiagnosis claims, can run into problems with what we call the statute of limitations. You have 2 years typically to file a claim against a health care provider for an injury. However, if you could not have determined that you have suffered an injury and as a result of something the doctor did wrong, within 2 years, you can extend that up to 4 years, but you have to file it within 6 months of the date that you knew or should have known that suffered an injury. So in a misdiagnosis situation, you can get a little extra time.
So with that filing, for somebody who might want to file one of these claims, what's the first step that they need to do?
The first step that we tell everybody to do in these situations is get the medical records. There really is the data that we need, or any lawyer is going to need, in order to evaluate the claim. We can get the medical records from the hospitals, the doctors involved, review those, and then make a decision about whether or not we think there's enough evidence there to go have it reviewed by experts to determine whether there is a claim that needs to be filed in court.
I think that's so timely. I do want to remind you all to give us a call at 256-536-0077 to get those legal questions answered. And again, right now we are talking about if you can actually sue a doctor for a misdiagnosis. I do have to ask, how often do you hear about this happening here in North Alabama?
This is kind of one of the most common questions we get, and so you'll get, we get regularly inquiries about the situation, Most of the time, if we look at a case, we'll look at the medical records, and most of the time there's not indication of some kind of negligent act or something that a healthcare provider did wrong. So we can, we dismiss those cases or turn those cases down fairly regularly. I would say probably 1 in every 300-400 cases I look at, we go into harder.
Yeah. So there was a recent Trump ruling that we are kind of going to go off topic here for a second.
Sure.
Just so we want to discuss this Trump ruling in the Supreme Court allowing him back on the ballot. Can you discuss that a little bit?
I didn't read the opinion, but I wasn't surprised. I mean, basically what the court has said is that the Constitution does allow people to be, candidates to be removed from the ballot, but it would not be a state-by-state thing. It would be something that the federal government or the Congress would allow. And it kind of just in terms of, and it was a per curiam decision, which means that all 9 justices signed off on it. So it wasn't a situation where this was a particularly close call in terms of the way the Supreme Court saw the law. But basically, I think they decided that it would create election chaos if every state was allowed to make a decision about who got to be on the ballot, and it would be, very problematic to have a fair election in that situation. Now, what is interesting is basically, since the Supreme Court has gutted the Voting Rights Act, how are they going to, manage this situation in the future in terms of a free and fair election? And that's yet to be seen.
All right. Well, I appreciate you for just breaking that down for
No,
us.
well, sure. I mean, the opinion, the result wasn't unexpected, and I think the opinion was, given that it was the complete, majority of the court, and it was unanimous. It's not unusual.
Yeah. Well, thank you so much.
Sure, no problem.
And if you didn't get your question answered, remember you can always call our friends over at Timberlake League and Brooks. I want to say thank you again, Michael, for joining us, and make sure you stay with us. We have more news after the break.